next news which makes the headline is Juvenile Justice Care and Prevention Act. So juvenile justice was again very much highlighted during the 2005 case, which happened due to the fact that there was a rape between some group of boys who were under 18 years of age, and which make again the injustice in the society. जिसके लिए लोग कई जगहों पे खड़े हुए, many NGOs do various kind of protest and there were certain flag march also. So Juvenile Justice Care Act was enacted in year 2015, which provide that a juvenile is a person less than 18 years of age. वैसे बच्चे जो कि 18 वर्ष की कम आयु में हैं और दे आर फाउंड गिल्टी ऑफ डूइंग सर्टेन ऑफेंसेस, तो उन्हें हम जुवेनाइल कहते हैं मित्रों. एंड दीज पीपल हैव हाईएस्ट पॉपुलेशन ऑफ परसेंटेज इन डूइंग क्राइम रेट्स इन द कंट्री. नाउ दैट इज व्हाई द गवर्नमेंट आल्सो क्रिएटेड a trial of the juveniles to conflict with the laws in the year of 16 to 18 years as a result in the cases. Government ने with the consent of Supreme Court of India prescribed that the 16 to 18 years of age people will be catered as adult person in various cases. Now the act brought the replace the Juvenile Delinquency Law and Juvenile Justice Care Protection Children Act of 2000, which fulfills the signatory of UNSCR and Hague Convention on Protection of Children and Cooperation in respect to Inter-Country Adoption 1993 and other related international instruments. Remember this fact. Then, as per Juvenile Justice Act of 2015, adoption of child in final civil court issues an adoption order. सो सिविल कोर्ट में अगर चाइल्ड एडॉप्टेशन ऑर्डर आता है मित्रों, सो द एज ऑफ द चाइल्ड ड्यूरिंग द कमेंसमेंट ऑफ द क्राइम एज एन ऑफेंसिव पर्सन विल बी कॉग्निजेबल एंड इट शुड बी टेकन बाय द डिस्ट्रिक्ट मजिस्ट्रेट इंक्लूडिंग एडिशनल डिस्ट्रिक्ट मजिस्ट्रेट, एंड also the speedy disposal of such cases will be done by the order of district magistrate. Then DM includes ADM to effectively coordinate and monitor the functions of various agencies responsible for implementation of Juvenile Justice Act. Then also it provides the district child protection units and special juvenile protection units and conduct the quarterly review of fluctuation of CWC and Juvenile Justice Board. Remember this, CWC and Juvenile Justice Boards that will done by District Child Protection Unit. Then what is the appeal? So there will be no appeal for any order made by the Child Welfare Committee. Child Welfare Committee के द्वारा CWC that is Child Welfare Committee के द्वारा जो भी order आएंगे उसके ऊपर कोई भी अपील नहीं होगी. And the bill removes the provision by providing aggrieved by an adoption of order passed by the district magistrate may file an appeal before the divisional commissioner within 30 days of such order. यानी कि वैसे बच्चे को जिसकी सजा होने जा रही है उसे अगर कोई अपील फाइल करनी है then he can file the appeal in front of the divisional commissioner and such appeal should be disposed within 4 weeks from the date of filing the appeal. अपील फाइल करने के 4 हफ्ते पहले ये चीज हो जानी चाहिए इन द डिस्ट्रिक्ट कोर्ट. रिमेंबर दिस वेरी वेरी इंपॉर्टेंट. व्हाट आर द बेनिफिट्स ऑफ दिस जुवेनाइल जस्टिस एक्ट? सो इट अमेंड्स द newer act between April 2015 and March 2020. About 19,000 children has been adopted on an average 320 adoption per month. As on July 2018, 629 adoption cases pending. 629 केस पेंडिंग है जुवेनाइल बच्चों के, and in various orphan houses which needs homes which will be adopted faster. Adoption cases are non-adversarial in nature and can deal with the process laid out. Then enhanced protection of children, both heinous and serious crimes has been clarified, removing ambiguity to ensure that children as much as possible are protected and kept out of adult justice system. सो बच्चों को एडल्ट जस्टिस सिस्टम में लाया गया है इन ऑर्डर टू मेक द चिल्ड्रन अवेयर अबाउट द acts that are they doing in the society against any women. So women protection के लिए बहुत important fact है मित्रों. Then smooth implementation of DMs and ADMs will be monitored functioning the various agencies and Juvenile Justice Board and District Children Protection Unit and the Special Juvenile Protection Unit will do it. Then District Magistrate in consonance with the Child Welfare Committee will also look into the matters of juvenile justice and the protection of women who is being accompanied by the crime, who is accused of the crime. Then following our norms and procedures, and we saw that the graph of juvenile justice crime elaborates 7 to 12 years, that is 3% and 1%. Then crime between 12 to 16 years 32%. 2009 and 24% in 2019. Oh, the rate is declining. Then in the age of 16 to 18 years, the rate of crime is increasing from 2009 to 2019. तो 16 से 18 वर्ष की आयु में हम देख रहे हैं मित्रों क्राइम की अपराध की संख्या बढ़ते जा रही है. दैट इज वाई government has prescribed that 16 to 18 years of children will be taken as adult person rather a juvenile. उन्हें adult के रूप में देखा जाएगा अगर वे कोई भी crime और offense करते हैं. Then status of disposed cases filed against children conflict with the law. Then 2016 we saw that the convicted was more than 35%. Then acquitted were near about 10% and the pending cases around 30%. Then 2017 rise in pending cases. Then again 2018 more pending cases and 2019 lesser pending cases, but the convicted rate was high. So conviction in juvenile case is again a very high issue of Indian society. Now 16 to 18 years of children are at intermediate level of their schooling. They are just passing the examination to go to the colleges, and after going into the colleges they are taken into the criminal activities due to various kind of challenges in the society. So now next news is interstate river water dispute, which makes the news for the Godavari River Management Board GRMB. Godavari River Management Board prescribed for the amendment of the Act, and Krishna River Management Board KRMB and Andhra Pradesh Reorganization Act of 2014. So background lies between the Andhra Pradesh and Telangana. APRA Act of 2014 contains provision for the constitution of an apex council by central government under Godavari River Management Board and Kaveri River Management Board. So Godavari River Management Board and KRMB are autonomous bodies. तो ये जो दो रिवर बोर्ड है मित्रों GRMB गोदावरी रिवर मैनेजमेंट बोर्ड और कावेरी रिवर मैनेजमेंट बोर्ड, they are autonomous bodies in which they can make their decision by themselves, and the operation of projects in the Godavari and Krishna river basin to ensure judicious water use in Andhra Pradesh. So Andhra Pradesh is facing the water scarcity in various places due to depletion of groundwater as well as mismanagement of water in Andhra, Telangana and Karnataka also. Then in 2014, two states provide that allocation was made on ad hoc and temporary basis, and set up of Krishna Water Dispute Tribunal 1 KWDT. Remember this friend. Then 1969 KWDT first was set up under the Interstate River Water Dispute Act of 1956. Remember this act, Interwater Dispute Act of 1956. And all projects on the Krishna, Jurala, Nagirula Sagar, Pulichintala and Sri Shailam. Remember this fact. कृष्णा रिवर पे इन जगहों पे डैम बनाए जा रहे थे. Then for smooth operation, Andhra Pradesh projects such as Sri Shailam right bank canal and power station उसको रोकने की जरूरत पड़ी. Then पोथी रेड्डी पड्डू हेड रेगुलेटर तेलुगु गंगा SRBC गलेरू नगरी. Then हंड्री नीवा सुजला सावर्थी मचुंटा मल्टी लिफ्ट इरिगेशन पूला सवाशी वेलीगोंडा नागार्जुन सागर राइट कैनाल हेड रेगुलेशन. Then पुचिंटाला प्रकाशन बैरेज Krishna Delta water and western and eastern canals. Then Bhiravani Tippa, Gajarodine. These projects were taken into consideration. And Telangana projects is concerned. So Jurala project, Jurala power station, Bhima project, Nettarma Paddu, Koli Sagar lift irrigation, Srisailam Kalkatti, Polamaru, Dindi lift, Nagarjuna Sagar, Hyderabad drinking water, Sitaramma lift irrigation, very important. Musi, Palayar and Tumilla and RDS project were taken into halting. So this diagram shows the schematic map of various river disputes, river water disputes in India, Indian rivers. Now we see that Ravi and Bias and Satluj are in the conflict in Punjab, Haryana and Rajasthan. So remember the origin point and meeting, they all are meeting Indus river. Now Narmada river also faces conflict which is originating at Achanakmar Amarkantak and merges to the Arabian Sea, जिसपे कि सरदार सरोवर डैम बनाया गया है मित्रों. Now which is in conflict with Madhya Pradesh, Gujarat, Maharashtra and Rajasthan. Then Mandil, Mandovi, Mahyadri river in state of Maharashtra. So Mandovi is located near Goa. यहाँ पे मांडोवी रिवर पे डिस्प्यूट हो रहा था बिटवीन गोवा, कर्नाटका एंड महाराष्ट्र. 3 states were in dispute on Mandovi river. Then Krishna river dispute in Maharashtra, Andhra Pradesh and Karnataka. So कृष्णा रिवर यहाँ से जा रही है, तो देख रहे हैं मित्रों ये ओरिजिन हो रही है महाराष्ट्र में, पासिंग थ्रू कर्नाटका एंड तमिलनाडु टू द इंडियन ओशन. Then Godavari river dispute with Maharashtra, Andhra Pradesh, Telangana, Karnataka, Odisha and Madhya Pradesh. Then Vansdhara issue with Andhra Pradesh and Odisha. Remember all these disputes for your prelims point of view. Prelims में ऐसे कोई भी क्वेश्चन आ सकते हैं. Now next point is entry 56 of union list gives power to the union government for the regulation and development of interstate river and river valleys. Then article 262 provide for the adjudication of dispute for the complaints against the interstate river water. So संविधान का article 262 which is asked in UPSC previous year question. Remember this act article 262 है जो कि interstate dispute water tribunal बनाने की बात करता है. Then Parliament by law provides that neither the Supreme Court nor any other court to exercise jurisdiction in respect of any such dispute. पार्लियामेंट ने इस पे कानून बना दिया जिसपे कि सुप्रीम कोर्ट या अदर स्टेट बॉडीज इंटरवीन नहीं कर सकती हैं कोई भी प्री एग्जिस्टिंग लॉज पे. देन डिलेज इन द डिस्प्यूट रिजोल्यूशन एडजुडिकेशन बाय ट्रिब्यूनल्स. ट्रिब्यूनल की जो भी जजमेंट्स पास हुई हैं उनमें भी बहुत सारे डिलेज हमें देखने को मिलते हैं. देन डिस्प्यूट अराउंड 1956 but the matter was referred to the tribunal only in 1969. 1956 में ये इशू एराइज हुआ था और 1969 में ट्रिब्यूनल में गया. हालांकि the authorities of water data makes the adjudication more complex and opaque procedure, and because of this the stakeholders in the interstate water dispute are again and again in conflict zone whether to go to the Supreme Court and whether to go to the legislative bodies to ask for making laws regarding the interstate water dispute. तो interstate water dispute बार बार बढ़ती जा रहा है और उसके लिए बहुत सारी कमिटीज़ बनाएगी जो कि अगेन एक परेशानी रही हमारे देश के लिए. Now next part is regions for the interstate river dispute. Interstate rivers के dispute के region क्या है मित्रों? Federal structure of nation. So the nation has state with own autonomy with state list. So federal structure क्या कहता है मित्रों? That is states which are under the union government, they have their own power to work for the development of their projects under the state list of 7th schedule of the Constitution of India. They can work independently by taking decisions at several parts. So this lead to dispute in the matter of river, and again the minimum support price regime, then again infrastructure development, then again shared river basin or transboundary groundwater, then again absence of transparent information, which again cause a problem of inter-river dispute tribunal. ट्रिब्यूनल के पास जो भी अथॉरिटी जाती हैं उनके पावर के लिए हम कंफर्म नहीं कर पाते हैं. डिपेंडेंसी ऑन द मेजर वाटर सोर्स ड्यू टू लोअर रेनफॉल, रेनफॉल की कमी एंड less precipitation again makes the problem of river water. Then lack of integrated approach between union and various states is not integrated. So non-integrated approach is again a big issue. So Interstate River Water Dispute Act provides for the streamlining of education, and interstate river water dispute makes present institutional architecture robust. Then River Basin Management Bill 2019 proposed River Basin Authority for regulation and development of interstate river and river water. Remember this fact for the prelims as well as mains. तो river water dispute act क्या कहता है? Adjudicating body बनाने के लिए makes the adjudicating body as well as River Water Management Board. Further, it provides the National Water Informatics Center, जिससे कि ऑनलाइन इंफॉर्मेशन मिल सकती है in terms of river water, sediments and their part and parcel of activities which are under the river basin. Then exploitation of river sand by sand mafias, they all are available on the NWIC. Then National Hydrology Project to maintain a comprehensive water resource data and collaborate with the leading research institutes to provide technical support to the central and state organization for hydrological extremes. तो हाइड्रोलॉजी प्रोजेक्ट्स में गवर्नमेंट हाइड्रोलॉजिकल डैम्स बनाती है, पावर स्टेशन बनाती है, उसको कैटर करने के लिए हाइड्रोलॉजिकल स्ट्रीम देखते हैं. वाटर रिसोर्स इंफॉर्मेशन सिस्टम इंडिया WRIS प्लस वाटर रिसोर्स इंफॉर्मेशन सिस्टम to learn about the water quality, exploitation of water by classification of data to Central Water Commission and to the Central Groundwater Board in order to look into the various perspective of water exploitation and the river water quality. Then new ministry has been launched by Government of India, that is Ministry of Cooperation, to streamline the cooperation movement. Banking Regulation Act of 2020, which gives RBI the cooperative banks and enable merger and acquisition of public interest. Remember this fact, under Banking Regulation Act, RBI can give license to the cooperative bank. So for cooperative bank, we are having separate Ministry of Cooperation. So under Article 19(1)(c) give protection of cooperatives. So that is again a fundamental right to form a cooperative. 19(1)(c) under right to freedom, freedom of expression की rights में form a cooperative. And under Article 43(b) of Constitution, Part 9(b) relating the theme that which guarantees the formation of association, cooperation or cooperative society by the people of India, which are the citizen of India. They can form the cooperative. And under 43B, that government and the states shall endeavor to promote voluntary formation and autonomous functioning, democratic control and professional management of cooperatives. कोऑपरेटिव के बढ़ावा के लिए आर्टिकल 43B में गवर्नमेंट एज ए बॉडी एक्ट करती है इन टर्म्स ऑफ स्टेट टू प्रमोट एंड प्रोफेस द कोऑपरेटिव्स. देन पार्ट 9B ऑफ द कॉन्स्टिट्यूशन in terms of running cooperative societies, which went to the extent of determining the number of direct cooperative society should have the length of tenure and even the necessary expertise requiring become a member of the society. So ऐसे expertise लोगों के बीच पैदा करना जिससे कि वे कोऑपरेटिव सोसाइटी में पार्टिसिपेट कर सकें, बिकम अ मेंबर एंड कोलैबोरेट विद द डेवलपमेंट ऑफ कोऑपरेटिव सोसाइटीज़, again becomes a duty of state government under Article 43 of Constitution of India. Remember this fact, very important for the prelims and mains. Then Forest Rights Act, friend. What is forest rights? So in the pre-independence period, we saw various conflicts such as Bhagwan Birsa Munda conflict in tribal nation, then Santhal revolt, Bhil revolt, Kol revolt in the various tribal areas, which take part in the tribal activities to protect the forest. तो फॉरेस्ट dwellers और वैसी कम्युनिटी, वैसे जनजातीय समूह जो केवल जंगलों पे और वन प्रदेशों पे आधारित हैं, उन्हें हम ट्राइबल कहते हैं मित्रों. एंड दे आर अगेन गाइडेड बाय द आर्टिकल ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया एज अ शेड्यूल्ड ट्राइब. सो मिनिस्ट्री ऑफ एनवायरनमेंट, फॉरेस्ट एंड क्लाइमेट चेंज हैज सेंट अ जॉइंट कम्युनिकेशन ऑफ ऑल द स्टेट in order to form expeditious implementation of scheduled tribes and other traditional forest dwellers act, that is called as Forest Right Act of 2006. Remember this act. So under this act, a statutory body, that is National Commission of Tribals, has been formed by the government of India, which looks into the matter of tribals, their forest right and their lands under the forest. It recognizes the best forest rights for the dwellers and scheduled tribes, other traditional forest dwellers, OTFDCs, other traditional forest dwellers, plus forest dweller state rights. Then which rights the forest for generation but the rights could not be recorded. वैसे लोग जो केवल जंगलों पे निर्भर रहते हैं, those are dependent on the forest in order to cater the needs, their livelihood and their daily activities in terms of economy and various factors of life survival. So those are called as the traditional forest dwellers. It provides individuals and community forest rights that categorizes into following types. इनके types देखते हैं. Now the act provides for the objective to strengthen and conservation regime for the forest and maintenance of ecological balance. तो UN SDG में भी हमने देखा था, यूनाइटेड नेशन गोल के 13 में भी फॉरेस्ट और इकोलॉजी को बचाने के लिए दिए गए थे. एंड इट ऑल्सो इनेबल्स द हिस्टोरिकल पर्सपेक्टिव ऑफ फॉरेस्ट dwellers. तो ऐतिहासिक ढांचे पे जिसमें अन्याय देखा गया है ट्राइबल्स के साथ, उसे भी ये कैटर करता है और कहता है दैट फॉरेस्ट ड्वेलर्स, दैट मीन्स ट्राइबल्स, शुड प्रोवाइडेड जस्टिस, इक्विटी एंड सर्वाइवल राइट्स फॉर देयर फॉरेस्ट कम्युनिटीज. Further, it ensures land tenures, livelihood and food security of forest dwellers, scheduled tribes and other traditional forest dwellers. So, the genesis of act shows that the wealth of nation meet their economic needs, जिससे कि British government was totally exploiting the tribal rights, taking all the forest produce, forest timbers, forest fruits and all the things from the forest, exploiting them badly, and which leads to first act of Indian Forest Act 1927. So people who are preparing for Indian Forest Services also learn for the Forest Right Act 1927, which provided for the tribals, forest dwelling communities continues to live inside the forest tenure in security. So ऐसी communities जो केवल forest में ही रहती हैं, अपने tenure को पूरा नहीं कर पाती, they are taken into the forest in security. Further, a symbolic relationship between forest and forest dwelling communities found recognition in the National Forest Policy of 1988. Remember this 1988 Forest Policy, Forest Act of 1927 and Forest Policy of 1988, and which needs to associate tribal for the protection, regeneration and development of forest. Scheduled Tribes and Other Traditional Forest Dwellers Act of 2006 was enacted following the long-standing demand of the tribal activities, groups and marginalized socio-economic backward class of the tribals which were deprived and which were exploited during the British regime. Now, we are taking a small break and we should continue after it.